the powers that be. But I think that the reality is that much like other rights that have been delineated by the Bill of Rights and the Constitution, they're just words on paper. And unless people actually exercise those rights and stand up for them, and by the way, is it the Bill of Rights that gives us those rights? These are questions that I think people need to be asking, because if it's something that was given to you, put on paper, is it really a right? Are these just privileges? Are these just something that we tell ourselves to make ourselves feel good? If we don't actually stand up for these rights, if we don't actually exercise them, then are they rights? Or is it something different? And I think that when you look at Professor Tracy's case, we're talking about a tenured academic who has more rights in an academic institution that is founded and literally, if you look at their bylaws, their operating agreement, this is embedded in in the institutional framework. So if anything, Professor Tracy had more rights than most people do when he's speaking in his capacity as a private citizen on a matter of public concern. And of course, you have in this case a clear violation of his rights. And the way we see it, and I think anyone who actually looks at the evidence in this case, which most people don't, they don't even want to look. They've already made up their minds. It's pretty clear, and I think the term slam dunk is appropriate for what FAU did. It was a pretextual, unconstitutional violation of Professor Tracy's rights to fire him for not reporting his blog on a form that was for outside employment. This is certainly an issue that will be addressed, hopefully, on appeal. But to make a very long story short, Professor Tracy should have won as a matter of law before it ever went to a jury on issues that the court refused to address. And this is one of many problems with the Tracy case. We have a federal court that is helping FAU and literally changing the law. And I think that's what people should be most afraid of. That you have precedent being disregarded, you have new precedent being created, and it's dangerous precedent. And it's precedent that will have a ripple effect, if not already having a ripple effect. When you think about what kind of an impact this case is having, I think you're probably already seeing a chilling effect. Of course, the chilling effect is hard to see because a chilling effect just means people aren't talking anymore. People aren't, blogging. People aren't, doing things that they would do because they feel protected.
Just happened. You know what I mean?
Well, what happened to Jim at FAU is that, obviously he was fired because he had a wildly unpopular view, and FAU, to their credit, played the slow game and didn't fire him, in 2012 when the heat was really on. But when they had I guess you can call it a solid opportunity, they took it 2 to 3 years later and got rid of him on a technicality. But the motivation is really clear. This is a person who is a problem for them, and they took advantage of a situation and got rid of him because of that problem. The problem being his exercise of his free speech. So that's what happened to Jim at FAU. What happened after that and in trial, I mean, his home was burglarized and his laptop was stolen. His website was the target of attacks. He's the target of personal attacks in the media and the target of attacks from folks who harass people who research and try to have another conversation about mass casualty events that isn't being had. And then eventually, he became a plaintiff and sued FAU. And, I think that part of the process in trial or in the federal litigation was above board. And then, there were some decisions that were not. And, something I tell people about like Supreme Court justices, and you could say this about probably most federal judges, because if you look at Judge Rosenberg's resume, it's impressive. She is a gifted intellect, if you will. Is that judges are so smart, man. These people are just really smart people. Say what you want about them and their decision making or whatever, but they are smart people, and they are very talented authors. And lawyers are professional writers. So they can write anything to justify any position, okay? So, you can take a position, you can make it sound above board, you can make it sound supported by the law, and it might not be. So I say that to touch upon, the decision to dismiss some of James Tracy's counts that were directed at the policy itself and calling the policy unconstitutional in and of itself, and that how could he fire somebody for violating a policy when the policy itself is unconstitutional, and those counts did not survive and make it to trial. They were never ruled upon really on legal technicalities, and those decisions were justified and supported by the law, but are they really? So that's something that happened to Jim in trial, was that he had very legitimate constitutional claims taken from him. They weren't even ruled upon on their merits. They were dismissed on legal technicalities or misinterpretations of law. And then we had evidence taken away from us at trial, and so we weren't able to show.
Hey folks, James Tracy, memoryholeblog.com. This is something that I have really seldom, if ever, done, is actually sit down with you and record a video. Kind of a fireside chat, if you will. The way that we've generally communicated at Memory Hole Blog has been through essays, it's been through posts. I'd like to change that by actually having a one-on-one with you and talk about what's going on, more recently. It's very interesting what's taken place in the past few days. As the New York Times reports, Indiana University has chosen not to fire a faculty member, one of its professors, because he had conservative, abhorrent, politically incorrect views. And so the provost came out and said, we're not going to fire this guy. We're going to respect the First Amendment. It's what took place at Florida Atlantic University back in 2013 when there was a different president, Mary Jane Saunders. And it's the exact opposite of what took place in 2015 with a different president that used a pretext to fire me because of the speech on my blog, memoryholeblog.com, as well as the attendant social media outlets on Facebook and Twitter. They use the pretext of, you got to fill out these forms because your blog is essentially employment. And so you have to let us know about that. Never mind the fact that there are plenty of other faculty members, probably better than 50%, that have Facebook pages, that have Twitter accounts and things of the like. You have to report this to us. Why? Well, because we're well aware of the speech. We don't agree with it, and we want to have the opportunity to censor it. Now, this is what ultimately took place with Tracy v. FAU, and we have appealed it. It is now before the 11th Circuit Court of Appeals. We have no idea what will actually take place, what will transpire. But that said, there was a great videographer, filmmaker that came down here to South Florida in spring of 2018 and did several hours of interviews with myself, with the Tracy v. FAU legal team, Louis Leo, Matthew Benzion, as well as Tony Mead, who's a well-known social media personality and what have you, and this guy's Peter Klein, and he did these. He had this fantastic idea of putting together a documentary, and it's just not gelled. But we really do want for that footage to come out because it presents a totally different perspective on Tracy v. FAU that has not been articulated by anyone. Certainly not the major news media. Certainly not the Palm Beach Post, the Sun Sentinel, the Miami Herald, the attendant broadcast news outlets, the television news here. They've just presented FAU's side. They just presented the FAU legal team side that I am a deviant. I was the professor who rebelled, who didn't fill out the paperwork. And the fact is, no faculty member at FAU or any other Florida public university fills out this paperwork, right? I was singled out. Anyway, this is just fantastic, revealing footage of different perspectives of a very complex legal case that is still unfolding at the appeals level. And I think that story is something that really needs to be told. So we're going to be releasing snippets of that over the next several weeks. So please do stay tuned for that. I think you'll find it very exciting. The stuff has been expertly videotaped and filmed, and I'm looking forward to it as well. So with that said, that's really more or less the update for now. We'll try to keep you apprised of what's transpiring at Memory Hole Blog and related free speech issues and things of the like. And we do appreciate all of your support and interest. Thanks very much. This is James Tracy for MHB, MemoryHoleBlog.com.
School system. The 13th Amendment says slavery is prohibited except for the conviction of a crime. For me as a law enforcement, that makes sense when you see our police statute book. I think when I started in 1998, the statute book was maybe like that. Now it's almost 3 or 4 inches thick. Yeah. So if you want to create a nation of slaves, you have to create more laws. More laws to be. And once I recognized that as a police officer, I started doing my policing differently because I recognized me arresting someone for a victimless crime was only serving the prison system, was only serving the corrupt system of system of racism. Because now if I arrest you for a drug charge, you can't live certain places, you can't get certain jobs and things like that. I think that adversely affects the community more than this person having a dime bag of marijuana in their pocket. Right. So once I recognized I was doing policing wrong, in my 20 years, we've never been trained on the principles of the Constitution. In the academy, we're giving maybe a day's worth of the Bill of Rights, but there's nothing in depth to talk about the principles and loving your fellow man and things like that. So I think that goes to the heart. Again, for me, it's education. The lack of education leads to being able to control a society. I can't recall who said it, but those with knowledge they fear, and those without knowledge they control.
And on an administrative leave.
Correct. I've been, again, a police officer for 20 years. If you look at my personnel file, I don't have a history of violence. I'm not, I don't insult people. I don't use profanity when I can. So yes, right now I'm currently on administrative leave, and if I were to be fired, I guess I would argue that I was wrongfully terminated, because I didn't use violence. I don't look at kiddie porn. I didn't threaten violence on my social media. I know we have a social media policy not to use profanity and nudity, things like that, and I censor myself a lot on my social media page. When I want to, blast someone and use profanity, I don't, because I recognize that I have to be a professional on and off duty. But if I were to get fired, I guess I would seek legal counsel to get my job back. But I also have a few months before I'm eligible to retire, so maybe I'll just bow out sooner than later. I don't know. Right. And again, Adam Lanza, this kid with no history of violence, mysteriously, for whatever reason, decides to kill his mother, drive to this school that he had no real relationship with, and then kill these children and teachers for, what's the motive? What's the reason? I mean, for me, it didn't make sense at the time, and I still don't get it.
There's never a motive, is there?
Right, there's no motive. It defies logic. Why?
In your experience as a crime fighter, when people perpetrate crime, is there a motive?
They're usually, and again, it goes to the war on drugs. It's usually, in most cases that I deal with, is drug violence or domestic violence. But for an individual to randomly go to a school and shoot children, it didn't make sense. And again, you hear, like you said, the 6 minutes for him to. Again, a lot of this, we wouldn't be asking these questions if we had, transparency. If we had video showing Adam Lanza getting out of a vehicle, dealing with Sandy Hook, going inside the school. I don't have to see dead bodies. I don't have to see dead bodies. Just show me him walking through the halls. Right. No, there's no videos. These modern day schools, no video. It doesn't make sense.
Well, Texas.
And isn't it convenient too with Sandy Hook and Parkland? These shootings occur in predominantly white, rich areas. And then what happens? They dump millions of more dollars into these communities.
Oh, yeah. It pulls at the heartstrings of the general public.
I made a post on it. I said, how come they dumping all this money into these communities? Is it hush money? So that was one of the issues Sun Sentinel had with me, because I said, again, asking questions. Because how do they dump all this money into these already rich areas, communities? My issue is, I think I want to get people to recognize America is changing. She's going through a culture shift. I tell people now we live in a fear culture. And I think what I want to express to people that we need to be able to ask questions. We need to be able to research history. For me, I didn't start understanding what was really going on until I started reading a few books. I started watching a few documentaries, listening to a few lectures. And for me, that helped open my eyes to what's really going on politically, locally, and globally. The hardest part is getting people to recognize that they're under a military psyop, and to actually open a book again and to educate themselves, because most people in America here are spoon-fed through the television, through the newspaper and the radio. So to actually open a book, I think that will be the biggest key to get people to actually do their own research, independent of or contrary to what the official narrative is. Because they say the three truths. The truth that they telling you, your truth, and then the truth is somewhere in the middle. So we have to be able to do our own research and to investigate. I don't know. I think our framers, they gave us the Bill of Rights and the Constitution, and modern society. Again, it plays into the Sandy Hook and the Parkland shooting. The Second Amendment is not there for hunting, and I know it may seem treasonous to the traitors of this country to say the Second Amendment is there for corrupt government. I mean, things are going to get to a certain point where we need our weapons to say, no, we're not going to take it anymore. And I think that goes to the heart of the Second Amendment. The average person, that's raised through government education, they don't understand the Second Amendment. So this is where I try to present that on my Facebook page, that the Second Amendment has nothing to do with hunting. It's about corrupt government. And when the government tells you, I guess what we saw here in the UK with the Alfie Evans story, I don't know if you're familiar with that, where this child was dying, the hospital refused to treat him anymore, but they wouldn't let the parents take the child out of the country. And again, if that was my child, and if I had a weapon, somebody's going to have the hell to pay.
Yeah.
So again, we need to get back to studying history. Sure. I mean, it is on record now, public record now, that the government, again, I think it all goes back to the government, deliberately put drugs in certain communities to destabilize them. Drugs, weapons. Gary Webb was a journalist that tried to expose the crack being put in certain communities. And what happened to him? He committed suicide with 2 bullets to the head. Yeah. So again, whenever you start veering off track, they either outright kill you or they destroy your credit, or they either kill you or try to discredit your character. And I think that's what's happening with Professor Tracy,
Yeah.
who I support.
And you as well.
Yeah, yes.
You know, I think that the silence that we experienced in this case from the media, particularly when it came to Professor Tracy's rights, was deafening. I mean, all you saw in the press was FAU's position over and over and over again, and that has a very tremendous impact on not just those who are, reading the papers or watching TV, which I don't understand why people still do that anymore. But the impact it had on the jury, who was certainly swayed by this barrage of demonization and marginalization and really reshaping the facts. And that to me was one of the most alarming aspects of the Tracy trial. We see a lot of cases get wall-to-wall coverage. If it's something that the media likes, they'll certainly pay attention to it, and they'll do what they can to give as much information about what's happening in the process and in court and on the record. And we spent a lot of time trying to educate reporters and mainstream media people about what was going on. And about the record, which is there. I mean, any of them could access the federal court system docket online and pull the emails and look at the record, And there was really minimal, if any, effort by most of the people who were purporting to cover this case to actually report what was going on. And in fact, we would have some really great evidence and really, great for Professor Tracy and really showed just how dishonest and deceitful the administrators of this university were being at trial. And some of these exhibits behind me really show what was really going on behind the scenes. And none of this was even mentioned. I mean, it was almost like witnessing bullying by whoever it is, and the media is right there kicking you, or kicking the victim, joining in, and he had it coming. I mean, this is to me absurd, particularly like my co-counsel said, from an industry that has benefited greatly from the First Amendment, and when you look at whenever the industry or the press is under fire for doing something, whether they're sued for defamation or what have you, what's the first thing that they say? Freedom of speech, freedom of the press. But where was Professor Tracy's freedom of speech? Where was his right to blog without being retaliated against? And not just by being fired. That was just one aspect of the retaliation. I mean, they changed his course schedules to conflict with his child care duties. Didn't hear that in the press. They canceled classes that he had without explanation, classes that were being offered. Where was that in the press? There was letters from constitutional rights groups that were condemning FAU for what they did and what they were planning to do. Where was that in the press? Where was the audio? This audio, which is one of the most important pieces of evidence in this case. You literally have faculty members and administrators on record just months before Professor Tracy's fired for not turning in his outside activity form. And you have the individual who fires Professor Tracy, who took the stand at trial and said that James knew, Professor Tracy knew what we expected, and he understood the policy. You have her on record saying the form that he's fired for not filling out completely or turning in on time needs clarity. She says this on the record. And this is in response to faculty members, including political science professors who teach constitutional law, asking the university to stop threatening faculty members with discipline under this policy until they can clarify it for everyone so that they understand it. I mean, this policy is very confusing, it's very vague, and it was used in a way that it should never have been used. And everybody knew that. Everybody knew it at trial, except for the jury, who wasn't allowed to. And I think that, and I'm hopeful that the higher courts will look at the evidence and apply the law.
But this, the term conspiracy theory and theories is something that exists to this day. And it's used to undermine the credibility in the public eye of journalists, of political leaders perhaps, of academics. All of these journalists and academics in particular are intellectual workers, and so their credibility is at stake if or when, or if there's even a threat of this term being used. So I think it's a very powerful type of kind of disciplinary apparatus that is wielded upon opinion leaders in the U.S. And I think it's very effective. It certainly was used against me, and I think that I was likely an example since it was used so prevalently. Well, I got a telephone call from a reporter at the South Florida Sun-Sentinel in early January of 2013. His name was Michael Clary. He was a general assignment reporter, I'm pretty sure. And he wanted me to, he wanted to discuss the fact that I was teaching a class called Culture of Conspiracy, and the fact that I was writing about the Sandy Hook Elementary School massacre on my personal blog, I believe. And he wanted to, I think, draw me out. I was more than open. I had nothing to hide. I think that we talked initially for probably about an hour or so. And he told me that I was being investigated by university officials and might be subject to discipline because of my personal blog. And I think that that gave me kind of motivation to get ahead of that. And that may very well be what the part of their technique was. Oh, well, if he thinks that, he'll definitely want to talk to us. We'll be kind of like the good cop, you know? And so I was very open. I said, yeah, these things are objects of study and discussion in my classes, things like JFK assassination and the Oklahoma City bombing. You know, I've shown documentaries involving these to create discussion and debate with students. After all, this is, I think, what students want when they go to university. They want to have a variety of perspectives. And so he wanted for me, ultimately, this Sun-Sentinel reporter, I believe, wanted for me to state on the record that there were crisis actors at Sandy Hook. And I said, look, I've never discussed Sandy Hook in class. It's nothing I've brought up because there's no scholarly research on it. And I would certainly not teach my blog in class, and I never did. I never brought it up or anything. But he wanted for me to state, yes, there were crisis actors. He called me up, and I was speaking to him out here on this patio, and I recall him calling me up and saying, he was, I think, cajoling me in many ways to state that, yes, there were crisis actors at Sandy Hook. I said, I don't know. I'm not. I said that's a possibility, but I have no idea. I know that Department of Homeland Security does contract with crisis actors, for example, Vision Box actors out in Colorado, but I don't know if that's the case, and I would never go on the record stating such. They wanted to conflate my profession with the personal blog and pressure the university to terminate me, or to get me to shut up, to get me to be quiet. The major newspaper up in Connecticut is the Hartford Courant. Its sister paper is the Sun Sentinel down here. They're owned by the same company. So I definitely think that there's a correlation there.
Absolutely, absolutely. I'm concerned about free speech. Well, okay, so there was a policy at issue in this case that essentially required employees at a university, public employees at a public institution, to report their activities outside of their job, which, just said plainly like that, maybe doesn't sound so objectionable. But when in application that policy is used to say, well, before you go speak about anything, you should tell us what you're going to speak about and give us the opportunity to approve that activity, well, then that sounds much more objectionable to me, and I would hope to a lot of people. And that's exactly what happened in this case, is they took this seemingly benign policy and then as applied to James Tracy and even other professors. So let's just kind of get this straight here, is that they not only said, James, you with this terrible viewpoint should have told us about your plans to express it and didn't do that, and so you're in trouble, tisk tisk. But they also were saying that to other people, other professors, and other professors were not happy about it and were complaining about it and wanted things to change, and that is evidence that we were not permitted to introduce at trial. So that is part of the reason why we feel we were strongly handicapped, because the jury totally missed the idea. They thought, oh, it's only James who was having this problem, and only James who thinks this policy was unfairly applied, was just totally untrue. And so back to the First Amendment issue is that, so now, public institution, and they want a public employee to tell you what your speech is going to be before you go speak it and give us an opportunity to say whether or not we, think you should go do that. That's terrible in my opinion. And then that policy and the constitutionality of it was never adjudicated in this case, okay? So that's something that we're taking up on appeal. And the reason why it wasn't adjudicated is also troubling, because the policy is part of a collective bargaining agreement. And, public employees in many institutions, they have collective bargaining agreements. It's just the way business is done. So now, if you just extrapolate that precedent, so now if we put an unconstitutional policy in a collective bargaining agreement, and then we limit parties to that bargaining agreement's ability to adjudicate the constitutionality of those policies in arbitration settings, well, then nobody ever gets to challenge the constitutionality of these policies of public institutions in a setting where these types of issues are adjudicated, which is in federal court, where constitutional issues are heard and where people have the capacity and the competence to decide them, and there's a system in place to ensure that they are decided in accordance with the law, Constitution, precedent, all that. So what happened in this case essentially puts a seal of approval on that kind of activity, and possibly prevents future harmed individuals from having their constitutional rights vindicated. So that is, those are the very real First Amendment implications in this case, and then also just the sheer fact that there was a factual, obvious, effort to target this person and remove him for his unpopular views. That is something that the First Amendment is, in the first instance, is there to protect somebody from being targeted for their unpopular views. And in these facts, in this case, that's what happened. And obviously the jury felt differently. I feel like they were confused, but they felt differently. And so now, with this set of facts so egregious, you can't find a constitutional violation. Well, what does that mean for people going forward when their facts aren't as egregious as this?
Sure. So, okay.
Off the dogs, the administration has been sending faculty members who are engaged in outside activity nasty letters. Letters of discipline or letters that threaten faculty members who are engaged in outside activity with discipline. There's a lot of fear and uncertainty. This is serious, and no one knows what outside activity the university is targeting.
We have certain rights as academics to engage in the community, to speak our mind, to engage and participate in the marketplace of ideas. And I agree with Tim. We need to have a cease and desist order from this vice president, who is not an academic, to stop writing letters to professors. I don't want to have to get a permission note before I write something on the internet or go to a meeting someplace that's unrelated to the university. This is absurd. It's insane.
But it's okay with me. But what you are saying here, and this is where it does not sit well with me, and I felt kind of disappointed, really, when I received an email. And this is what the email said, and extremely important to note, that FAU has requirements including but not limited to receiving permission from the Office of University of Communication and the Office of the Provost prior to speaking to the media, including student media, every single time you engage in such activity. So what you are saying, already you have movement in the direction to curb us from talking to the media. And here
Let me ask you as a prefatory matter, and I'd ask this question of Mr. Ovalman. Did the university require everybody to fill out the form? Or was that something that the professor was free to do or not, depending on whether, in his judgment, there was something reportable?
Right. Much like your time deadline in court here, it was not aspirational. It's required. Article 19 of the collective bargaining agreement specifically lays out the requirements to advise the university when you're going to engage in specific activity. The form we're talking about just implements that policy. I think the Article 19 policy...
But if I didn't engage arguably in the activity, was I required to fill out the form?
If you did not engage in the activity?
Yes. I'm a professor at the university, and I didn't do anything that came within a country mile of what the policy said. Was I required, did the university require me to fill it out? Was everybody required to do that?
You had to fill out if you have something that is within
Okay,
a
so
country.
the answer is no, unless in my judgment I was of the view that there was something reportable.
Anything that takes time.
Well, let me come at it in a different way. As a federal judge, I'm required, as is every Article III judge in the United States, to fill out a financial disclosure form. I got to fill it out, whether I think it makes sense or not. If I own 1 share of Coca-Cola stock, common stock, I must report it. Is it your view that under these rules of the game, a professor was required to fill out these forms under all circumstances? Or did he only have to fill it out when there was something reportable? Do you understand the thrust of my question? I'm not sure that I understand how this worked at the university. I'm trying to have you folks sort of illuminate that for me.
You know, if you're asking whether the professor has to sign a blank form if he's not engaging in any
Yes.
other activity, I don't know the answer to that. I do know if he's engaging in...
So they didn't require everybody to fill the form out. The university didn't send the form to every single professor, associate professor, adjunct, et cetera, and say, here's the form, fill it out, whether there's something reportable or not. Do I have that right?
I don't know if they had to sign a blank form. I just know that they had to report outside activity as set forth
So
in the
if
policy.
they had outside activity, they had to report it.
For sure, that's true.
But if they didn't have outside activity, they didn't have to report it.
If they had no outside activity, there would be nothing to report. I don't know.
And therefore, they didn't have to report it. I'm not trying to quibble. I'm just trying to understand whether it was precatory or mandatory and who made the decision.
It was mandatory to report outside
If you
activity.
had an outside
If you had
activity
outside
that was reportable.
That part I know for sure.
Correlation there. Now, a couple of the blog posts that I did write on Sandy Hook, I submitted to Michelle Shazudovsky up at Global Research, globalresearch.ca, and he ran those, and this was like within a couple of weeks of the event having taken place. And I was just asking questions about, say, H. Wayne Carver, the Connecticut medical examiner who presided over these autopsies. Why was he laughing and guffawing through the press conference that he had on December 15th? It didn't make any sense. So I transcribed the press conference, and as I was transcribing it, it seemed more and more ridiculous. The fact that he's laughing at the deaths of these children and the autopsies. So I wrote that, and published that as a piece, I think on December 24th of 2012, and then submitted it to Global Research, and from there it went all over the world. And I think that, I can only surmise that the powers that be, if you will, prompted the Sun Sentinel to contact me and to get me to go on the record so they might be able to use me as an example. This is something that should not be commented on because there was an understanding at that time that this was getting a lot of play internationally, as Global Research goes all over, not just in the United States. And I think that I was really just basing my study to a large degree on research that had already been done. There are researchers doing stuff and publishing it on YouTube and on their own blogs, and we're doing great stuff, far outpacing the mainstream press. And this was just within a couple of weeks of the event. But I was on the inside, if you will. And I've often thought of my situation as being something of a whistleblower in a way, because this is verboten. This is not something that you can discuss as an academic, as quote unquote conspiracy theory, you know. And I think that once I got tenure in 2008 and began talking about things like 9/11 or broaching those topics on Facebook, my leftist academic friends, my progressive left friends, in some cases would really come down on me, and with this sort of boilerplate language like, well, the conspiracists say this, but of course we can't believe that. That's not true. It seems so formulaic and dishonest, really. And I think that kind of planted a seed that I disliked the hypocrisy within my own ranks. We thought of ourselves and think of ourselves as being as seekers of truth. I was involved in some organizations and I think identified as a kind of leftist professor myself, and yet the left has this sort of mental block, and I'm not sure if it's willful, if it's something that's a put on or what, with regard to these deep events. So they, in effect, become de facto guardians and defenders of the official storylines, which itself, I believe, is very dishonest. And they're doing it at least with the partial knowledge that it is not truthful. What they are doing is, I think, in service of the state.
I'm James Tracy, and I would like to welcome you to Memory Hole Blog's YouTube channel. MHB was launched in March of 2012 as an extracurricular writing project when I was a tenured associate professor of journalism at Florida Atlantic University. The blog gained notoriety a year later in 2013 after I published a series of posts analyzing what I consider to be as very intriguing press coverage of the Sandy Hook school massacre and the Boston Marathon bombing.
Perhaps we as a society have been conditioned to be duped.
It became quickly apparent to me how the mainstream media did not really appreciate having their coverage of these events questioned. And so, as a result, they tried to get me fired by creating a whole lot of publicity around myself and the blog and attaching my blogging to the fact that I was a professor. And at the time, my bosses at FAU essentially said, look, our board of trustees really don't like all this controversy and what you're doing with the blogging, but we really can't do anything about it because it's, after all, free speech. A few years go by and the same administrators came to me and said, sorry, but you haven't filled out these forms to have your blog, so we're going to have to fire you. And I said, what? So 4 years later, I'm still in federal court with the university over my job. I didn't go into academia to make a lot of money. It sounds pretty idealistic, but I really wanted to contribute to making the world a better place. And I believed, and I still believe, that teaching and the creation and sharing of knowledge can help to do that. I believe that that's true if you're just reaching one other person and revealing something to them in a way that they've never seen it or considered it before. And that's what good journalism does as well. Most journalists I've found come in contact with believe that if they can get the truth out there, some good will come out of it. But now more than ever, truth tellers are punished for saying anything of substance. It's like we've returned to the rule under the British Crown in the 18th century, which held that truth was not a defense. And the greater the truth, the greater the slander, the greater offense. And I don't know if it's possible to be committed to truth and certain principles and be a part of the university system in the United States any longer. Professors are now getting fired for simply saying something that one person or one group or another claim to be offended by. My idea of any learning environment is to challenge people, and if you can't take it, there's no way you can actually learn and broaden your horizons and grow as an individual. Fortunately, we still do have the internet and the local coffee shop or the pub, provided we social distance. There are a lot of really talented bloggers and YouTubers than me, but I'm here to try my best in the same way I was when I started down the road to teaching 25 years ago. So I really hope you like some of what you see here, and thanks so much for stopping by.